Good afternoon, Ms. Retief.
A very good afternoon to you, Deputy Chief Justice.
Are you ready?
I am. I trust your will.
Well,
Good.
I see that you're a mom of one, a daughter of 22 years of age.
I am indeed. Does that make us kindred spirits?
Sorry?
Does that make us kindred spirits?
Indeed it does,
Then-
although mine are many more than yours.
I understand.
You hold a BLC and LLB and an LLB degree
That's correct.
obtained from UP
The University of Pretoria. That's right.
in 1989 and 1991.
Correct.
Okay.
From 87 to 91, to be exact,
Uh-huh.
Deputy Chief Justice.
All right. You started your foray into the workspace in the Ministry of Justice as a judge's registrar.
I did.
How old were you then?
I must have been about all of 20.
Yeah.
It was a very small stint. I actually just helped out a young lady who was going on a studying sabbatical, and it was for a 3-month stint at the Palace of Justice in Pretoria.
How did you find that experience?
Well, it was rather exhilarating, but it's when you're a law student, you don't really understand the intricacies of it all.
Yeah.
So one makes a number of faux pas, but my judge was awfully gracious and awfully kind, and it was a wonderful experience. But I think if I know what I know now, I may have very well got a great deal more out of it than I did at the time when I was that young.
Yeah, that's usually the case. A lot of things are wasted on the youth.
Absolutely.
Yeah. You did your articles in 1992 to 1993, and then started as a professional assistant in 1994.
Yes.
And then you left that firm. You were with Routledge Modise, then you went to Newton's.
Yes. Deputy Justice, what happened there was Rutledge's had a Pretoria office, and I went to the Pretoria office. That Pretoria office then pulled away and became Newton. So it was really, in effect, one and the same firm. It just changed its name.
I see.
Yes, that's really what happened.
All right. Then you decided to strike it off on your own,
Yes, I did.
and you did that for 10 years.
I did.
Then you decided to join the bar
Yes.
in 2007
Correct.
to date.
Correct.
Have you regretted that choice at any stage, that
Not-
decision?
Not at
Not.
all, Deputy Chief Justice. It's as if at that particular time in my life, in late 30s, a number of my colleagues asked me why, and we teased and said perhaps a midlife crisis. But in truth, it was such a form of growth, and it was the right space at the right time.
Yeah. You do a lot of interesting things. One of your passions is child welfare, I see, and you've worked with organizations such as, is it Door of Hope, Door for Hope,
Correct.
and Baby Save. What's
Yes.
that one? Baby Savers SA. What do you do with those organizations?
Yes. Deputy Chief Justice, my practice as an advocate concentrated not primarily, but mostly on medicine. And a great deal of that became fertility law.
Yeah.
And in fertility law, obviously what flows from that is children's and children's rights. And at a stage, I started doing a number of work for KELS. And it just so happened that the difficulty that we have with abandoned children became a topic of discussion. And I then formed a think tank, so to speak, with KELS to try and see whether or not, if we look at our existing legislation, whether or not we have what we call safe haven laws with regards to abandoned children, but more specifically centering on what about these young ladies? Are they the criminalization thereof? Is it abandonment per se? And then on equality in terms of male-female equality, it became the test on if a woman gives up her baby and is found criminally charged for abandonment in terms of the Children's Act, what happens then to the young man who basically just then walks away? So it became quite an interesting think tank, and we've got quite a lovely group. And the Door of Hope is actually one of these homes that takes care of abandoned children. But the pertinent interest here is that they have what they call a baby saver, which appears to be a controversial issue. And a baby saver, I always say, it's just a little bit like a Moses basket, really. It's a conduit where a lady who wants to be anonymous places her little one in a particular container at the doors of the Door of Hope. So it's a drive for the recognition of a body called Baby Savers South Africa, in a nutshell.
Very commendable. You're an expert in the law of fertility.
Yes.
That's a very niche area of the law.
It is indeed, but it's an exciting part of the law.
Yes.
It's as if the law is trying very desperately to catch up with medicine, which is fantastic to be part of, because you learn a great deal. One's mind turns all the time.
Yeah. You haven't had an opportunity to write a judgment in the area of the law, though?
Not yet. I'm hoping to do so. That would be quite a privilege.
Yeah, yeah. You mentioned a brief you received from CALS to consider advising on aspects involving a class action in which the concept of obstetric violence, and I've never heard of this concept, obstetric violence as an infringement of a constitutional right is to be claimed. Can you tell us a bit more about that? That got my interest all piqued.
Yes, it got my interest too, but the pity is that although I was approached to be part of that think tank, and it's because I do a great deal of medical negligence work too, and gynecological, unfortunately, when I was asked to look at the papers once and settle the papers once the class action had been finalized, I wasn't given the papers. So I was also waiting with the bit between my teeth, but was never released on it.
Oh well. Okay, I'm going to leave any questions on your acting stints in Gauteng and judgments you may have written to the Judge President of the Division, to whom I'll hand over now. JP Mlambo.
Thank you, Deputy Chief
Thank you very much, Deputy Chief Justice. Good afternoon, Advocate Retief.
Good afternoon, JP.
You've acted for 26 weeks in total in Gauteng.
That's quite correct.
Right. And I see in those acting weeks, you've had 4 weeks in the opposed motion. That's where you would have accumulated reserve judgments.
Yes.
But I note that it doesn't appear like you've reserved for longer than a month or 2 months at most in all your judgments.
Yes, JP. It was a wonderful exercise to do that flow chart, because I never really thought about it.
Yes.
But when I looked at it critically, I saw that most of the opposed matters were extempore. Those that were written, obviously, I think 2 months is a fairly good, fair reflection.
Yeah. You haven't done work in the agent court?
I haven't. I did
But
notice.
you may have got 1 or 2 pass-ons. You didn't have that?
I didn't have pass-overs, but if it gives you any comfort, JP, in the 15 years that I've been an advocate, I have practiced in the urgent court.
Yes.
I'm quite au fait with what I have to argue as counsel as substantial redress, and I think I'd be quite comfortable with deciding whether or not that aspect has been proven and dealt with. The other thing is that in the opposed motion court in 2019, when I had the taste of my first stint, it was quite a triggering moment for me, in the sense that I realized that the 29 years of experience that I had and life experience almost came from my big toe and out of my mouth, meaning that if one looks at the 2019, I was able to get to the nub of the matters rather quickly, which I think is quite important in urgent matters.
Yeah. Thanks for that response. I think perhaps this is accounted by the number of weeks you've acted, which is more than the divisional threshold anyway, even though it may be viewed as illegal.
I see.
But we do have a threshold.
I see.
You've not been allocated special motions
I have not.
as well as special civil trials.
No.
Right. In your stints in the appeal courts,
Yes.
did you have any criminal appeals that you dealt with?
Yes, there are a number of criminal appeals, and I think I did note them down.
Yes.
Yes.
Okay.
And there's one in the, I think I
Yeah.
placed one in the bundle, JP.
You are actually in the list that's gone to the president for the conferment of silk. Am I correct?
Yes.
Yeah. You have not heard yet. I think there's a wait now this year, no, last year and the previous year.
Correct.
We've not heard anything from the
We
presidency.
wait eagerly,
Yeah.
JP.
Now, your appearances, you're an advocate. You appear in the High Court, that's a given. Have you had appearances in the SCA and the Constitutional Court?
Only in the SCA,
Yes.
JP, but not in the Constitutional Court.
Okay. Now, I know that the bar has found nothing to criticize you on. They're actually writing good reports about you and the reports they get from people who've appeared before you when you were sitting. I, as JP, want this commission to recommend candidates who will hit the ground running. The leadership sitting in that table there has been complicit in denuding the Gauteng division of its capable judges. So I need to build that capacity again, because when,
Understood.
you know, Gauteng attracts all this big work.
It's a very busy, busy division, JP.
Yeah. So I'm saying this to you to say, you've acted, you've been in practice, you're a specialist in fertility law, you've been around. You consider yourself to be more than ready to become permanent.
When I reflected to apply, that was a test that I had to consider. And it's a resounding yes, JP. If I look at being an attorney, if I look at being a counsel, if I look at being a lecturer, if I look at being an examiner
Yes.
and a mediator, the answer is yes. Over 30 years, I think I have a great deal to give the judiciary. I'm 54 years old, which means I've got a good term left in me.
Yeah.
I've good health, and I'm energetic. I think I am certainly ready.
Yeah. You were nominated, but you didn't want to accept the nomination until you consulted widely. And one of those people who consulted was myself, remember?
Yeah, correct.
I was out of the country. You had to wait for just over a week before we spoke. And you wanted to know whether, as JP, having seen you work, I feel you should accept the nomination. And the rest is history. You're sitting here.
Indeed.
Yeah. Thank you,
for
DCJ.
that.
No further questions.
Thank you, JP. MEC? All right.
Covered.
Any questions, colleagues? Commissioner
Thank you very much, DCJ. Good afternoon, Advocate.
Good afternoon, Commissioner.
Yes, I read your profile here and what is on the table. For me, it's quite clear that you embrace transformation, because herein you train admitted attorneys, you train people around issues of BEE on how to file claims. And this is very, very good according to me. But my question is, in the three arms of government,
Yes.
which one is the least transformed in your view? And in that sense, what is it that can be done to fast track transformation so that all of them must be equal? Before you even respond to that, let me tell you why I'm asking this.
Yes, because it gives me time to reflect,
And
Commissioner.
yes, let me tell you why I'm asking this. Just looking at what we're talking about all the time here, I get a sense that we're using old laws in the current dispensation. For example, the Criminal Procedures Act, it is of 1977. When the president sets up a commission of inquiry, whether it's Zondo or what, he uses an act of 1947.
Yes.
When you institute a claim in terms of the state liability, you use an act of 1969. I can go on and on and on and tell you that. And in my respective view, I think that the least transformed arm of government, it is the judiciary. What is your take on that?
Well, if I reflect on it, and if I accept your answer, because I haven't had time to really give it some thought, but let's run with your answer. Perhaps I would agree with it. Sorry, perhaps, thank you, JP. Perhaps I would agree with it only insofar as it appears that those that apply those laws perhaps have not understood the value of the Constitution and the Bill of Rights and what's incumbent upon them to do. So in other words, it's not necessarily a case of transforming the bench as it is, but it's the transforming of application and mind. So in other words, it means that everything is here. Our entire toolbox, the Constitution, here to my left, is here. But it's encouraging, demonstrating how this tool gets used not only for constitutional issues, common law, and customary issues. So, yes, I hope that does answer.
No, it's okay. I just wanted to test you
I see.
on that particular aspect. Just on a lighter note, DCJ, last year I gave my daughter 2 books, law books. The one I think is written by Lawrence Baxter, and the other one by Marinus Weigers, and said, this you must go and read. Now, the other time she comes to me, she says, you know what, Rex has got a lot of money. Either he takes people to prison, or Rex is having a lot of suing people. I said, no, Rex means the state, in that sense.
Sweet.
You must understand it. Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner. Any questions for this candidate from the virtual platform?
Yes,
Yes.
DCJ.
Okay.
Go ahead, Commissioner Singh.
No, thank you very much, DCJ. Good afternoon to you, Advocate Retief.
Good afternoon,
I'm
Commissioner.
on the virtual platform, as you can see. I was very interested to read in when you presented yourself that during your practice, which traversed general litigation, medical malpractice litigation featured prominently.
Yes.
Now you have been involved in medical malpractice legislation and litigation. And I want to ask you this question to get your wisdom. Now, of late, we know from my experience in Parliament, I think one of the biggest contingent liabilities the government has on its financial, is land claims liability and medical claims. And there have been a number of interesting cases regarding claim for medical negligence. With recently a landmark judgment in the Eastern Cape,
Yes.
where the court ordered that they should not pay money to the victim, but rather, provide care for a young patient. So that's something landmark. But in other instances, we found even government commenting, and they've got the SIU to investigate what they call fake medical negligence claims. And to that end, they want to introduce a bill to limit the amount of claims to about R1 million, and then also have more settlement rather than taking 16 to 24 months to deal with these claims, which it does. And, just to quote from one of the articles, the Eastern Cape Health Department says the ruling of the Eastern Cape will help shield the public from, quote unquote, unscrupulous lawyers who, quote unquote, cheat litigants. How can you help South Africa in this matter if you are appointed as a judge? Thank you.
It is an interesting question, but at the same time, it is a little bit vexing. And I say that it's vexing because I can understand that principle applying and that thought process applying when one refers to claims of medical injury relating to road accident fund claims. But when one is dealing with situations where people have been hurt factually, in other words, the inquiry here is actually somebody that's really been personal injury to body that has traumatized them, and whatever the case may be, we won't go into that. That is a factual consequence, so it cannot be fabricated. But the important part here, I think, on the fabrication, even sitting as a judge, is actually the computation of the quantum. So if we keep liability aside and we accept that there is liability, we are finding more often that the realm of experts giving lip service and providing reports that actually don't speak to the heart of the actual future medical treatment is on, let's say, the rise. What that does require, if matters do go to trial, is very proficient advocates who can cross-examine these experts who are supposedly at the top of their field. But more importantly, the balance simply is for the judiciary to understand, or not understand, they understand it, but to apply the principle that, yes, one is entitled as an exception here to accept expert evidence, but actually, if it's not reasonable to reject expert evidence, and that doesn't happen, and it could happen because of volumes, it could happen because there's been consensus with regards to amounts of claims that are made. I'm not entirely sure, Commissioner, whether the bill, and I haven't seen it, so I can't comment, but I'm assuming it's much like the Workers' Compensation Commissioner bill. In other words, I don't know if it's a no-fault liability. I'm not entirely sure whether that common law principle is going to be not adhered to. But I'm assuming you're talking to capping of claims. Is that right? All right. So once you're capping a claim, yes, once you're capping a claim, the other thing that you're also doing is you're taking away the redress of somebody, and in certain circumstances, children who are, and adults who are mentally impaired, who can't care for themselves and can't work for a dime. So the moment that you cap that, depending on whether the common law claim still stands, that's a different issue. But if the common law claim falls away, you are really taking away the only chance that a person has at negative inter esse, placing them in the position they would have been had that very incident, or we call it insult, happened. So it is an important investigation, but one must consider each side exceptionally careful. And I suppose the best way to do it is to put yourself in that position at the end of a knife and realizing that you can't do what you do anymore and your claim is capped. It's a mouthful, but...
No, thank you. I think the Deputy Minister is taking careful note of what you are saying, because I know there's a separation between the judiciary and Parliament and executive. But I just hope that your wisdom can prevail and you can somehow make comments to that bill, even if you are appointed, or recommended for appointment as a judge, because this is certainly a matter that vexes, I think, not only politicians, but the country as a whole.
Yes.
Because even one court even went out to suggest that it's the departments that are at fault, and the kind of a very poor care that they are offering our people in these hospitals. That's largely the cause. So, I think one has to balance this very, very carefully.
Yes.
Thank you. I don't know if you have any comment to that.
I think that you've hit the nub. In essence, the practitioners are the voice of a patient, in as much as legal practitioners are the voice for the client. And sometimes that falls foul and people get really injured. Yes, and the only way that they can go back to where they thought they could be, which cannot be if you're injured personally, is by looking to the law. But thank you for your question, Commissioner.
Thank you very much. Thank you, Deputy Chief Justice.
Thank you.
Thank you, DCJ.
Thank you, DCJ. Good afternoon.
Good afternoon, Commissioner.
May I just ask, the DCJ asked you about the portion of your application where you reflect that you were briefed to give an opinion on novel issues. I think that's how you put it.
Yes.
And what was referred to was obstetric violence.
Yes.
Did you provide the opinion to CALS?
No.
All right, and what happened to the matter?
I'm actually not sure. The Think team actually never came back to me. So what it was is I was briefed in another matter dealing with sexual discrimination in the workplace. And through that, they found out my expertise in medical negligence. And so we then started having our initial, shall we say, preliminary chat. I then received a brief to say that documents will be coming to you to settle the class action. I must just wait. It's coming. And then a follow-up, it is coming. But it didn't in the end.
So apart from these preliminary chats, absolutely nothing, you did absolutely nothing on the matter?
Nothing concrete to add any particular value which I would have liked to.
Because I'm just trying to understand, Mr. Retief, why that would find its way into your CV if actually you literally did nothing on the matter.
Well, I think the important part or the thrust of it is, Commissioner, is that it basically states that my expertise in a particular field, working for KELS, they considered that actually giving me the brief would add some value in that area. And I found that I thought that was wonderful. In other words, it gave me credence in a particular area.
Are you aware that there are a number of juniors working on that matter?
I am.
And did you consult with those juniors?
No, we consulted on another matter on the safe haven, and that's how I know that they're on that particular matter as well.
All right, then just the last thing that I need to touch on is, you deal with transformation under a number of headings. I don't have time to deal with each one of them, even though I would have loved to go quite carefully through it. But let's deal with transformation through the upliftment of women.
Yes.
Now, you say that the transformation happens at two levels. When you were at the sidebar, you employed candidate attorneys who are women. Am I correct?
Correct.
So when you come to the bar, that I have a question, because what you reflect here is that you set up what you call an informal women warrior group.
Yes.
Before I put my question to you, I just want to lay the basis. You've gone to great pains in your application and in your CV to portray yourself as a specialist, both in relation to medical negligence, but specifically also in relation to fertility litigation. Am I correct?
Yes.
And so you see yourself as having specialist skills in both areas.
Well, I think it goes further than that, Commissioner. It's not only that I see myself, it's that when I applied for silk, and as you're well traversed with the application of silk, my body accepted and I carved a particular niche in that particular area of law, and I was recommended on that basis. So it goes further than just my own sort of, shall we say, subjective approach.
That leads me to my question.
Yes.
How many black women have you worked with as juniors in your matters?
Yes. So the way that, let me go back. I can amplify how I deal with my practice and with the ladies within my group. Presently, I'm in a group called Group 33, and the reason for the move, amongst other things, was simply that the idea behind Group 33 is that it utilizes a third. In other words, it's a third race, a third gender, and a third seniority. The beauty about the chamber is that it is rather small.
Mr. Retief, I'm sorry, I don't want to interrupt you. We've got limited time.
All right. Well,
So
let's get to the thrust of it. Let's get to the thrust of it.
So, how many black
Yes.
women have you
Yes.
used as juniors in your matters? That's the question.
4.
Four.
Yes, 4.
Is that 4 fully on brief with you?
Yes.
And that's throughout your career?
Yes.
Right. And the 4 have been involved in medical negligence matters?
Medical negligence and fertility and donation, yes.
In all of the 3 areas?
Yes. And in terms of where I couldn't, in terms of cash or whatever the case may be, the attorney couldn't carry a junior, I create spaces. And that's why the preamble of the Group 33 was so important when I answered the question. Because the spaces are that where I can't give them the work, I then hand work over, particularly to tax, to other colleagues. I pull in on commercial matters where I have the ladies that work within my group. We have a very close-knit senior-junior conduent practice together. And the Woman Warrior was actually to pull that all together to try and expand where they wanted to be, because most of them don't necessarily want to be with medical negligence. In fact, most of them don't.
And just last question, apart from the 4 black juniors, how many other juniors have you worked with?
2.
So 6 juniors in total?
Yes, so two other juniors, one being a black male and one a white female.
Thank you. Thank you, Chief Justice.
Commissioner Baloy?
Thank you, Chief Justice. Good afternoon, Ms. Retief.
Good afternoon, Commissioner.
Ms. Retief, it's really a follow-up. It's become a follow-up on a discussion with Commissioner Pillay.
Yes.
You say in your application that, maybe let me ask the question first.
Yes.
Are you appointed to CALS?
Yes.
Appointed, what does it mean? You're employed at CALS?
Yes, and what they did was they appointed me as an advocate for a period of time, and I think my duration was 2 years. So from time to time, they would appoint me as a preferred advocate on a particular matter, and I have a letter of appointment for 2 years.
Okay.
Yes.
So you're appointed to be briefed on matters. You're effectively on their panel for 2 years.
Correct.
That's effectively what it means.
Correct.
Okay. So what does it mean where you say, at page 44 of your application, you say, I think the heading you have there is transformation through upliftment, transformation through civil society organization, and you speak about CALS, and yet in your explanation, all it is that your involvement with CALS, all it is that you're on the panel to be briefed. What does one make of that? And maybe let me level up with you that I'm uncomfortable because on the face of it, it seems like you represent something that is not in that paragraph. And that takes me back to the obstetrics violence issue as well. That was my concern there, that if you answered that you were waiting for the matter to come to you, you don't know what it is, then why is it there? And it's not telling us anything other than to create an impression that is not.
Yeah. Commissioner, the reverse is actually true. So with regards to the appointment of CALS, it started with a labour matter. And actually before that, it started with me being introduced to CALS giving a pro bono mediation course. I then received a brief to do a labour matter relating to sexual harassment. Seeing what CALS does and seeing what they do, I realized that on a number of my matters, and particularly the safe haven, which in fact is not originally a CALS matter, it's a matter which I took to CALS. In other words, I said, look, do you have the appetite to deal with this particular matter? And together with another large firm in Johannesburg, we've created this think team to forge ahead to do what we think is right together with Dr. Rosenberg on this matter. So that's it in a nutshell. There's no misrepresentations at all.
All right. Thank you, Ms. Retief. Thank you,
Thank you.
DCJ.
Thank you, Commissioner Baloy. Any further questions for this candidate, colleagues?
Yes,
Oh, yes,
DCJ.
Prof, go ahead, please.
No, thank you very much. Good afternoon, Advocate.
Good afternoon, Commissioner.
Thank you very much. A point has been made that the division to which you are going to be appointed receives all these big matters. And in most instances, some of them are review matters, be it against the state generally or some other institutions.
Yes.
I'm not really sure the extent to which you have had exposure to admin law, but I just want to ask you a general question.
Yes.
In relation to admin law generally.
Yes. Thank you for... Yes. Sorry,
One of the most crucial decisions that a legal practitioner will have to make when instituting a judicial review will be to decide whether to rely on PAJA directly,
Yes.
or to bring an application in terms of the constitutional principle of legality. I just want to get your understanding as to the circumstances under which one can bring an application under PAJA, and if PAJA is not applicable, then under the principle of legality.
Yes. Commissioner, it was a lengthy question, but I just want to understand the first part of the question, as I understand it, is, if I'm correct, is if I've had experience with reviews. Was that the first one?
Yes, basically, yes.
Yes, basically, and the second one then was amplified to ask whether or not one understands the difference between a review in terms of PAJA or a review in terms of legality, where,
yes,
for example, the state reviewing its own decision. With regards to the first one, in my practice as an advocate, I also did petroleum work, meaning that I dealt with a number of matters on the either site or retail license, the acceptance or rejection thereof, that went through a process, an appeal process. Once that internal process was exhausted, the only remedy there was review. So on that basis, in the law of petroleum, I dabbled in reviews. As far as being a acting judge, if one has a look at my stats, there's a number of matters which are PAJA reviews, and one in particular, a legality review relating to the public protector. That particular judgment I have placed in the portion of my judgments. Coming back to the last question, the PAJA review, I suppose it's easier for me to state that if there's an administrative action by an organ of state or a natural person or a juristic person that is acting as a public body and has a public interest, and there's a decision that affects somebody's rights, then one is entitled to go in terms of PAJA. In fact, the entitlement is actually you must. It's prerequisite. But in a set of facts where one finds that the very decision is a body who is the state, then one sits with a situation where the review must be brought in terms of the law of legality. So in other words, if the door is closed in terms of the statute being PAJA, then one then looks to a legality review. If that answers your question?
No, that is your answer, and I will live with. Thank you very much, DCG.
No further questions then, colleagues? All right. I guess you'll be relieved to hear that the interview has come to an end, Ms. Retief.
Thank you.
Unless you still want to have a go at it.
If this is the end of the road today, then I'm grateful, and
Right.
I'm very, very thankful.
Thanks to
for
you
the
for
time.
making yourself available.
Thank you very much.
You're excused.
Thank you, commissioners. Thank you.